Good evening, everyone. It's James Gunter here with Present Pillars, back again for another part of our series, Due Process for Dads, getting your license back. So we're here with Blair Johnson, Attorney Blair Johnson, who will be covering this topic for us. If you have any questions for us, please leave them in the comments. And like always, we don't want to waste your time, so we'll jump right in. So I want to introduce Blair Johnson. Blair, how you doing?
Great. Evening, James.
Yeah, good to see you. I want to say thanks again for helping us out at the expungement fair. Huge success. Thanks again for that.
You're welcome. It was my pleasure, and we helped a lot of people.
Oh, yeah. All right.
So I'll kick it off.
Yes, sir.
I'm ready. All right. Well, evening, everybody. I am Blair Johnson. Been practicing law here in St. Joe for about 11 years now. I do a number of different areas. I think, as I said last week, expungement is one of them. I do a lot of family law. We're going to do some family law stuff at the end of the series starting in January next year. But tonight we're going to be talking about driver's license restoration. So critical, obviously don't need to tell. If you're watching this, you know how important it is. Either you don't have a license or somebody who doesn't needs to get it back, or you just want to learn. But we live in a part of the country in the state that doesn't have a lot of public transportation. And so getting anywhere to do anything often requires a license, especially in the wintertime. Can't be riding bikes. So I'm here to explain the driver's license restoration process. We'll kick it off first with some acronyms we'll be using here tonight. Driver's license restoration, DLR, is just a general term that attorneys and courts use for the process of getting your license reinstated. SOS, Secretary of State, or the Michigan Department of State, they're the agency responsible for managing all licensing for operating motor vehicles. OHAO is the Office of Hearings and Appeals Oversight. Acronyms changed over the years, but that's what they are now. They handle all the hearings to the process for helping people restore from revocation their driving privileges. DAIS, DAIS, is the online portal to apply. We'll be talking about that a little bit later in the evening. BAID is the interlock device that a lot of people will have to have installed in their cars, and I'll explain when and how that works a little bit later. And then DWLS, driving while license suspended or revoked, is something I see a lot of and can be real problematic when you're trying to get your license back. When you keep driving, you don't have a license and you get popped for that. It adds on more time, makes it harder for you to get your license reinstated. So there's a whole bunch of other acronyms, but that's the top ones for me. I always start out by explaining, driving is a privilege, it's not a right. There is some constitutional law that's addressed that, but in the time that we live in, it's not a right to drive, so it's a privilege. You can lose your privileges to drive for any number of reasons, most of which we're not going to talk about tonight, but they can be failing to appear in court, failing to pay court fines, using a fake ID, getting too many points on your driving license. But the ones here at the bottom are the ones that we're going to be talking about tonight, and that's causing an accident resulting in serious injury or death, and more often than not, the commission of certain drug and alcohol-related offenses while driving a vehicle. The reason for losing your privileges is going to determine the course necessary to get them back, and we'll talk a little bit more about that shortly. And license restoration, it's an administrative hearing process for safety reasons. It's not a crime. The crimes are often, some of these are not crimes on this list here, but crimes can result in loss of privileges or impacts on your driving privileges. But going along with that, privilege is not a right. The process is to ensure that the roads are safe for people who are out there driving. So first thing is, how do I find out what my license status is and what's on my record? You got to go to the Secretary of State. That's handled exclusively. There is some oversight with the circuit court in the county where you live. We'll talk about that a little bit later. But the first thing that I always ask from my clients is, please give me a copy of your Michigan driving record. It has everything that I'm going to need and everything the Secretary of State has on you that has an impact on your right to drive legally. You can do that. The easiest way is to get a copy online. A lot of this stuff we're going to talk about tonight is available online. Secretary of State did an overhaul of their website, I want to say maybe 3 years ago. It's actually super user friendly right now. And so you can just, pop on there. You can just Google, obtain my Michigan driving record, and it'll take you to the page. Costs $11. Or you can go to the local branch office and get a copy of that. Your MDR, your Michigan driving record, is going to show all of the licensing events on your license. So that would be convictions, sanctions, penalty waivers. What I'm talking about there is 5 years ago now, the Secretary of State rolled back a lot of the financial penalties for drinking and driving related offenses. If you lost your license back then, you may recall you had to pay $1,000 2 times, 1,000 one year and 1,000 the next year to get your license back. It would vary depending on the offense, but ultimately, the state realized, and the legislature realized that it was prohibitive for people to get back on the license because they couldn't afford to pay these fees. So they rolled them all back. Now, one thing I do want to point out, it's probably not as common now, but when that first went out, is that if your license was revoked because of drunk driving, simply be reversing these fee penalties didn't change that. So for a small portion of people, they had their privileges reinstated, but for a lot of folks, they were still revoked because of underlying criminal offenses. Your MDR is also going to show prior attempts to get your license back, hearings that you did or tried to do, and any restrictions on your license, as well as your status, whether you're in revoked status, expired status, or suspended. And then it'll always tell you what steps you have to take to get your license back. So getting your driving record is the first thing you can do to get on the road, is getting that information from the Secretary of State, so you know what to do with it, or a lawyer is going to help you get your license back. So what's the difference between a suspension and a revocation? So a suspension is a temporary loss of privileges. It applies to a lot of the non-driving related offenses on the list earlier, like failing to pay tickets, failing to pay fines, failing to pay child support. And restoring those privileges can often be done by simply meeting the underlying obligation that led to the suspension. In some cases, you may have to go to an informal hearing. It's called a reexamination. And at that hearing, they may need additional documentation, like a physician statement. One issue may be, are you medically cleared to drive? Attorneys can be involved in this process, but often are not. And again, it's not an indefinite loss of privileges. It just means you have to do a couple of things to get back, and then it's automatically restored. Revocation, which is what we're going to be talking about mostly tonight, it's an indefinite loss of privileges, and that applies to the driving related offenses like drunk driving. Restoring your privileges requires you to do a formal hearing process that we're going to talk about through the Office of Hearings and Appeals Oversight. And this is the process where a lot of people are encouraged and do get an attorney. And not just because I am an attorney, but because I've done a lot of these revocations now, about 200 or so, a little over 200. Really hiring an attorney to help get your license back is probably the best thing you can do. It can be expensive, but this process is super difficult, and a lot of people lose because of technical mistakes. And lawyers like me who do this often enough know what the Secretary of State is looking for. So I hope when we get through this, you're going to learn a lot more about it. But still, it can be really, really helpful to have that attorney represent you. So why was my license revoked? Revocation of driver's license can be the result of 2 or more drunk driving offenses, which includes impaired driving within a 7-year period. And these are automatic, just happens. You got a conviction, 2 for DUIs within a 7-year period, then automatically your license is going to be revoked. Or if you have 3 within a 10-year period, or a conviction resulting for an offense, driving an offense that results in death or serious injury to another person. Revocation can also happen for medical conditions. For a lot of folks, it's maybe it's the elderly, and they can't pass a vision test or a hearing test sufficient to drive. And so their license is revoked. And at times they also, if you get a restricted license and violate those restrictions, or have a faulty reading on a ignition interlock device, your license is going to be revoked again. If your license is revoked, you will have to do the formal hearing process. There's no way around it. And if you will not be able to obtain a license in another state, whether you go to another state or you currently live in another state, until what they call a hold in Michigan is been cleared, and you have to go through the formal processes in Michigan to do that. Now, decades ago, these states didn't talk to one another, but now they are really keyed in. And so if you try to go to another state and get a license, they'll do an interstate check and see if your license is revoked in Michigan, and it will not allow you to get a license in that other state. I did run into an issue last year where a number of clients that I had in Indiana went, after driving for several years fine, went to reapply or renew their driving license there, and they were flagged because for some reason Michigan dumped a whole bunch of caseloads. Some portal opened up in the interweb, I don't know, and these folks had a Michigan DUI and a revocation from the early 2000s, is where I saw my clients, and suddenly they couldn't drive legally. And this was, I think I had about 5 clients of mine who ran into this issue. So not going to be able to get a license in another state till you deal with Michigan if your Michigan license is revoked. And you will most likely be required to drive on a restricted license for 1 year with an interlock device in your car before you're going to be given full privileges. For clients that live in Michigan that I've done this for, it's probably been about 150 of those that live in Michigan. The rest live out of state. I've only had one person in my 10 years or so of doing this that went from having no privileges to having full privileges in one hearing. So what we're talking about is likely going to take 2 hearings to get back to full privileges if your license is revoked. So how do you apply? And again, we're talking about license revocations here. You have to complete the hearing request form. It's known as the SOS 257. You're going to want to use your Michigan driving record to fill that out. List all driving and non-driving convictions involving alcohol or drugs. These may include convictions in other states. Some of these convictions out of state do get reported to Michigan. Some do not. But there may also be non-driving offenses like domestic violence, armed robbery. If you were intoxicated and committed any of these offenses, you're going to need to list those. Also, like minor in possession, drinking alcohol under age 21. Those have to be on your record, on your application. Sometimes it will show up on your driving record, but sometimes they won't. All of those have to be in there. The instructions on the form say to disclose those, so disclose them. You're going to have to describe the type, quantity, and frequency of your use of all substances at the peak of your use of each substance. And I'll talk a little bit more at the bottom about why that's so important. Even if your license was revoked for drunk driving, they are going to want to know about your use of marijuana, any use of cocaine, heroin, you name it, pills, Vicodin, opiates, all that stuff, because they're looking at any concerns for any substances that may impair your ability to drive. So all substances have to be listed. Detail all your prior attempts to maintain abstinence. What we're talking about is relapse. Secretary of State's very concerned when somebody has been able to stay sober for a certain length of time, and then they go back to using again. Because what they're looking for is, if you had a substance problem or have a substance use problem, are you going to be able to maintain abstinence going forward? So you got to detail all of those prior attempts. Disclose all your prescriptions that you may have taken in the past or are currently taken for addiction, pain, or mental health. And some of these are controlled substances. And if so, you'll need to get a form that completed by your doctor, a form that's available online, verifying that you are following the prescription as prescribed. There's no concern about your ability to drive so long as you use the prescription as prescribed. You need to disclose any past and ongoing recovery efforts that you're making, like AA, NA, counseling. And if you're doing those things, you got to get a sponsor. You got to get a sponsor. And that's one of my pro tips at the end. If you've ever had a license in another state, then you need to get a copy of the driving record from that other state. And the form asks for that information. The things you got to watch out for. And I feel like I'm talking really, really fast. And there's so much to go through in here. And I mean, James would certainly tell me if I was, I know. But there's a lot of ground to cover. And I'm happy to share these slides too when we're done, if anybody needs them or wants them. But the first thing you got to watch out for is not disclosing all of your use of substances, even if it was years ago and even if it was only a couple of times. The reason I can tell you this is I've seen it over and over and over again, where clients of mine have decided for themselves. The form says you got to disclose it, put it all down, but they've decided it wasn't that big of a deal. It was years ago. It was when I was in high school. I'm 50 now. I only did it a couple of times. The problem is if it comes out at the hearing and you say, oh yeah, when the hearing officer says, did you ever smoke marijuana? I did when I was in high school, but it was a long time ago. But you didn't disclose it on your application. You didn't tell your evaluator, we're going to talk about that a little bit, about it, then you're going to lose because your credibility is shot. Please don't think it wasn't important to you, because I guarantee if it had to do with drugs and alcohol, it will matter to the Secretary of State, and it's better to disclose it now rather than try to hide it. Not disclosing your prior periods of abstinence and relapse. Your past attempts to stay sober, like I said before, will matter. And again, a lot of this is, it doesn't make it on the application. It doesn't make it in the evaluation. But then if a client or you, if you're doing this and you're getting your license back, if you say, well, yeah, there was this time and I did, stay sober for a couple of years and I went back, but you didn't disclose it earlier, you didn't tell your evaluator about it, it's going to hurt your credibility. A lot of these are not intentional mistakes. This is, again, the lawyer thing. Like, people don't mean to necessarily mislead the Secretary of State. They don't do this. I do this a lot. And these are the kinds of things that I've seen people make mistakes on that come back later to haunt them and they get denied. Don't minimize your past use of substances, whether intentionally. Just be transparent about it to everybody and everything in this process, so that you can get it out there and it can be addressed by your evaluator and considered by the hearing officer. And also, a tip is, there's a box on the form that says administrative review. Don't check that box. You want a hearing. You want a hearing to explain any discrepancies, any differences between any of the evidence that you provide before your hearing. And if you check administrative review, they're just going to look at your documents. You're not going to have a right to a hearing. You may not know that, but I'm telling you, that's what that means. So that's the application. You get that done, then the next thing you have to do is get a substance use and evaluation and 12-panel drug screen. The evaluation is on the SOS 258. This form has to be completed by a licensed substance use counselor, and these are all the acronyms that I put up there as to who those are. And these are people who are trained on how to diagnose and evaluate addictions, essentially, and substance abuse. The evaluator must attach a copy of their testing instrument. That's not a common practice for evaluators, but SOS requires it. And those are the SALC, the ASI, the MASS, the SASI-3. And so your substance evaluator is going to know those acronyms, but they got to attach that testing instrument to their 258. The prognosis must be at least good or excellent. If your prognosis, which is, how good you're going to do long-term, if the prognosis by your evaluator is only fair, guarded, or poor, don't use that evaluation. Don't use it, because fair is 50-50, and the standard of proof in these cases is clear and convincing evidence. There's case law that says 50-50 isn't clear and convincing. So you got to get another one, or you got to reconsider whether or not now is the right time for you to apply if your prognosis is only fair, guarded, or poor. My preferred evaluator is NARAD Health in St. Joe. I've been working with them. They also are it's the same group that operates Harbortown Health Treatment Center in Benton Harbor. I've worked with them exclusively, I think, for about 5 or 6 years. The reason why I go with them, number one, they do the drug screen there. They know exactly how the drug screen needs to be done because those are tricky. But I also meet with them usually at least once a year, if not more recent, to keep them apprised, because Secretary of State changes the rules on these things. So up until a couple of years ago, they were accepting alcohol as a valid panel on a substance on a drug screen, even though it wasn't in their original rules. And then all of a sudden they started enforcing that and saying alcohol is not going to be one of the panels that we consider valid. So if you go get a 12-panel screen and one of them is alcohol, then you only have 11 valid panels. That's going to be rejected. So I met with them to say, hey, they changed the rules again, you guys. We got to update it. Now, if you're out of state, you're going to have to find an evaluator out of state. And I've done probably, I want to say, with clients in maybe 8 states at this point. And it just takes a little bit of education, because if they do this work in their state, Michigan is very different. Michigan is really, really tough. That's what I've heard from the evaluators I've used in the other states, is they just can't believe how hard it is in Michigan to get your license back. But NARAD Health is great. I use them for all of my clients. Watch out for, again, not disclosing all your use of controlled substances, even years ago. Got to do it, because the number one reason why people get denied, and I'll say this at the end, I'll say it now, is that the stuff that they submit is not consistent. The application, the evaluation, the letters of sobriety that we're going to talk about, and their testimony at hearing. If it varies, one person says one thing, another says the other, and it relates to your use of substances, relapse, abstinence periods, that's an easy button for Secretary of State to deny you. So that consistency is really critical. Tell them everything. Just tell them everything, and don't make decisions for yourself as to what you think is important as it relates to drug use or alcohol. Again, the drug screen panel must be 12 panels minimum. It can't include alcohol, which is kind of crazy, because most people lose their license for drinking. And the reason why is that alcohol doesn't stay in your system long enough for it to really be meaningful for them to measure. So you got to have a 12-panel screen for any number. Really, they aren't picky. It just has to be 12. It can be more, but one of the 12 can't be alcohol. And it must have at least 2 integrity variables. I offer this because sometimes people will go to another testing agency, and sometimes those agencies don't have these integrity variables, and those are specific, gravity, pH, and temperature, I think, on the third one. But they got to have 2 out of 3. Otherwise, again, the Secretary of State's going to reject it. And so I work with NARAD. They know this is what Secretary of State needs. We've got to do it this way. And then whatever the evaluator recommends that you do as a continuum on your continuum of care, which means how do I keep staying sober? You got to do it. You got to do it. If they recommend you go to AA and get a sponsor, you go to AA and get a sponsor. Because if the person who's the expert in the field, who's done the assessment of you, says you should do these things to stay sober in the future, and then you don't do them, and it comes to the hearing and you tell the hearing officer that, or they figure it out, it's an easy denial. So follow through with that. And again, at the bottom, I'm saying, listen, you want an attorney that's got a strong collaborative relationship with an evaluator, because SOS is real tricky, and they're super particular about this stuff. And you gotta have everybody on the same page. Just checking my time here. Good. So the next thing is you got to obtain letters of support or community support letters. I call them sobriety letters from people in your community, a cross section. They're looking for a broad swath of the people or communities that you interact with. Your work environment, your home environment, that's who you live with, family. If you go to church, if you do recovery, they want to know They want to hear from everybody because we're looking at, can you vouch for us that this person has been sober? So we're looking at all these different aspects of your life. It helps to Secretary of State to know that you are in fact sober, because otherwise you're the number one source of information. And I tell my clients this, like, you're going to go to the hearing and testify, you're filling out the application, you're going to the evaluation, and the evaluator is given a recommendation, but you're the source of information. These sobriety letters are the only opportunity for people out other than you to vouch that you are sober, to vouch that you are following the law, to vouch that you are going to, you've got a recovery plan that you're working. So they're really, really important. Your writers should state how long they've known you, how often they see you, that they've not seen you drink or use drugs since your date of sobriety. Date of sobriety is extremely important. Know it at least a month in a year. Say it over and over again. And any knowledge they have about your recovery and treatment. You can submit, the instructions say 3 to 6, but hearing officers tell me all the time, they'll take up to 10 letters from different people. And the letters must include the person's name, their address, phone number, and they're going to have to be signed and dated by a notary public. These letters are probably the biggest headache for my clients. I get it. I understand it, but they're so critical. They're not character letters. It's not, are you a good person? It's literally, think about, this is a person who would be testifying under oath, because they're going to be signing in front of a notary, that you are sober, you are abstinent, and if called, to testify in court, they would say so. That's what they're interested in. They're not interested in about the other stuff. They're not interested in, like I say at the bottom, about whether or not you deserve to get your license back. Please don't say that. It really actually kind of offends. I've had hearing officers kind of call that out. Just focus on, it's not, are you a good person? Are you deserving of this? It's that you have been sober, and they got to say specifically how often they see you. It's vague if you say frequently, occasionally, regularly. Letters get denied all the time for those reasons. 1 to 2 times a week. I see them daily. I see them, I see them 4 to 5 times a month, whatever, every Sunday night. But it's got to be, and it's got to be often enough that it's meaningful. If this is the aunt who comes from Arizona and sees you twice a year, their opinion, or I would say opinion, their testimony about whether you're sober or not, it's not going to be meaningful, right? If they only see you a couple of times a year. So it's got to be somebody who sees you often enough, got to be specific in the letter about how often it is exactly. Clearly state that they have not seen you drink or use drugs or suspected that you were under the influence of either of those since your sobriety date, because you could get drunk and then come to work. So suspicion is also important. I've learned that over the years. Throw that in there, that they also don't think that, suspect that you've been drinking when they've seen you. And as I said, at the bottom here and at the beginning, this is the only source of information other than you. It really, really matters to the Secretary of State if you have other people who are willing to vouch for you, and the letters check all these boxes. It's the only information other than you that they're going to have available to determine whether or not you should get your license back. And then how do I do it? How do I apply? I guess it's still the same heading, but do it online. Please don't send these applications in the mail. During COVID, it was a nightmare. And I still hear from people it's a nightmare, that if they send their application in, I don't know if it's because Lansing has just stopped spending time and money on the, paper mail stuff. I'm sure they still accept it. It's still allowed. But if you want to ensure that your stuff gets to them, do it online. You just go to milogintp.michigan.gov. You got to create a profile and a username and password. And this is the DACE. This is the driver appeal integrated system that I was talking about. They set it up during COVID. It works like a charm. It is outstanding. I can tell you that the electronic side of these appeals in the last 5 years, with their website access, their online portal, the video hearings, it is really humming right now. And I really want to commend the Secretary of State for dumping all the money that they did into this, because it was bad for a while. If you submit everything online, you're going to get an email with a case number that says, we got your stuff. Perfect. I've had clients send things in with certified mail. They get the receipt back saying it was there, and then they follow up, and Lansing says, we lost it. And oh, by the way, your stuff is too old now. You got to start over again. This will ensure that doesn't happen. You will get a notice of the hearing in the mail. You're only going to get that confirmation email. That's the only thing you'll get electronically. Everything else will be paper form. Your notice of hearing will come usually 3 to 4 weeks after you send your stuff in. And then that hearing is going to be about 4 to 5 weeks out in the future. And I'll give you a timeline at the end of this thing. And then if you need to upload additional evidence after submitting your application, you can. You can even submit evidence after the hearing if you need to, and that can be done online. But please, even if you need to get a family member or friend who knows how to use the internet better than you do, do that. Do that. Don't send things in the mail if you want to be sure that your stuff is going to get there. So what do you have to prove? What are the standards? What's the law to win? Michigan Administrative Code rule. It's an administrative code, 313, otherwise known as 257-313. We call it, it's Rule 13. The standards are by clear and convincing evidence. That's kind of like beyond a reasonable doubt in criminal law, but a little bit different. But basically, clear and very hard, the highest level of burden of proof in civil law, that you have maintained complete and continuous abstinence from alcohol and drugs for at least 12 months. They're not even going to look at you if you haven't been completely abstinent, even if you didn't blow a little bit over the legal limit. You got to be completely drug and alcohol free for a year before you can even apply. Number 2, that you have a lower minimal risk of relapse. In other words, you have an adequate relapse prevention plan. They want to know that you're going to stay sober in the future. And if you get tempted, what are you going to do to ensure from going back to drinking and using? I should say this. So if your license is revoked, the term that's used under the law is that you are classified as a habitual offender. And because you are habitual, you may not think that you are a habitual drinker or user of any particular drugs or alcohol, but the Secretary of State is going to not diagnose, but you are labeled a habitual offender if you have lost your license because of 2 DUIs in a 7-year period, 3 within a 10-year period, anything like that. So that's what they're looking at. Are you going to stay sober in the future? Is there a minimal or a low risk to reoffend? Will you follow the law? One of the issues here is these driving on a suspended license. It kills people. When you have, thanks, Denaro, when you have, what happens? I'll tell you what happens. So when you get your license revoked, if it's for 2 DUIs in a 7-year period, you have to wait a full year. All right. If you get 3 within a 10-year period, you got to wait 5 years. And then you're eligible to go back and ask to get your license back. But if you get popped for a suspended license driving ticket, revoked license driving ticket, they add on a year from that date. So I've had clients who have been sober or not sober. They've been eligible to apply for 10 years, 15 years. And then they get caught driving. They could have applied in that period and didn't. Then they get caught driving without a license and they're kicked out another year. So if that happens, get a lawyer. Get a lawyer who can help you maybe plead that down to a non-moving violation, because that's not going to get reported to Lansing. But if you take a hit on that, you have to wait a whole other year. And it tells them you don't really care about the law. You're just going to keep driving. And listen, I mean, my clients, I got to drive. I got to go to work. I got to take my kids. I hear it. But I can tell you the Secretary of State doesn't care. It's public safety. That's what we're looking at. Your license is taken away. Don't drive anymore. And right, what ends up happening, we live in small towns, is that the police get to know your vehicle. They're just waiting. They're just waiting to pop you. So it's bad all around. Find another way. Ask people, please, to help you get to and from places. And finally, that your substance abuse problem is under control, likely to remain under control in the future. This is the hardest one. How do you predict what's going to happen in the future? But you do it We do it by showing you've been sober for a long time with these letters, and that you have a recovery program underneath it at your work, whether it's counseling, it's AA, that sort of thing. The evidence going to help you win is a substance use evaluation that has at least a good or an excellent prognosis. Strong letters of sobriety that vouch for you, that are consistent in every single way about your sobriety. That your testimony at your hearing is consistent with the documents. I spend a good amount of time with my clients trying to prep them that if you change your narrative at the hearing, it's going to negate all the work that we did. That's where it's out of my hands. I can do document stuff, but when my client is testifying at a hearing, it's out of my control. I can try to save them, but just please be consistent with what you submitted before. Incredible. Involvement in some kind of continuing professional or peer recovery-based program, whether it's SUD, substance use disorder counseling, AA, NA, something. And having a relapse prevention plan, that is detailed and thorough, right? What if you go to your cousin's wedding and suddenly somebody asks you, do you want to have a drink? And you're like, maybe. What's your plan to get out? Also, as a note here, and it's up there at the very top, I didn't pivot to this, but you're not going to be given credit if you're abstinent while incarcerated on probation or parole. There's a case that says the Secretary of State can't give you, because they don't know, are you staying sober because you don't want to go back to prison or jail? Or are you staying sober because you acknowledge that drugs and alcohol are a problem for you? Unfortunately, can't change that. So you're not going to be given credit for the 12 months that you got to have before you apply until you have been released from probation or parole. Question, James?
Yeah. So do you have any, like maybe a list or any resources where maybe people have AA, or would you say SUDS? Is there a list of resources?
Counseling.
Yep. Is there a list of resources?
So, all of those. So we're talking AA, Alcoholics Anonymous, Narcotics Anonymous. They all have, NA.org. I think it might be different. I know AA.org is AA's group. So there's an app for AA called the Meeting Guide app. Super, super helpful. That tells you where your meetings are geolocated. So if you are in another place, you can just open the app and it'll default to, it's Sunday, it's 5. This is the meeting, and you can set your radius. It's called the Meeting Guide, the Meeting Guide app. And I'm pretty sure if you go to AA.org, you'll see a link to download it. SUD counseling, off the top, I can't think of any resources. I mean, if you Google it, substance use count. Riverwood does a lot of this stuff for folks. But there are others, NARAD does. They actually, in addition to the testing side, they do the counseling side. And NARAD is a terrific resource locally for us.
Okay.
Got it.
Yep. Thanks.
Yeah, you're welcome. So, so I think I'm done with the slide. Appreciate the question. It's a good question. How might I lose? So I just, not to beat a dead horse, failing to disclose any and all substances on your application, evaluation, or at the hearing. I can't tell you how many times clients of mine have said, you're my lawyer, I'm going to tell you, but I'm not going to tell, the hearing officer. Oh my God. Listen, I don't know how to tell people, listen, who you are is who you are. And these are nervous. My clients are nervous when they have this, and a lot of them just sing. Oh yeah. And again, it's not often intentional. Sometimes they forgot, but I'm really intentional working with my clients to say, what did you do? Did you ever do this drug? Even one time? Did you ever drop acid? One time? Please say it now so we can get ahead of it. Because obviously if you did it in your 20s, it's not going to be that big of a deal. If you're, 30 years later now and your primary drug of choice is alcohol, but it's going to matter if your hearing officer hears that you did it when you were younger, but your evaluator didn't. And your evaluator didn't include that as part of their analysis and their prognosis for you to stay sober. Inconsistencies between documents. It is the death knell I'll say it at the end. I'll say it now. My number one job as a lawyer in these cases is I'm a glorified fact checker. I fly spec the heck out of my stuff before I send it in, because once it's in, I can't change it. And again, the hearing is going to be a bit of an anomaly, but everything else, I got an opportunity with my client to hone the narrative. Let's do it. Let's get it out now. Let's make sure there's no inconsistencies across any of your stuff. Not having an active recovery program or difficulty supporting your program with knowledge. So gone are the days. I can tell you this because I've been doing this for 10 years. I was doing this with my dad before as an admin, before I went to law school as a paralegal. And gone are the days where AA sign-in sheets were enough. I can tell you these hearing officers, they are knowledgeable about 12-step programs. They ask my clients some really good questions about the program. And if you don't know the answer because all you're doing is going to get your sign-in sheet done, they're going to find out. Trust me. Don't try to pull the wool over the eyes of your hearing officer. A lot of my clients don't even realize that they do it, but I realize it. You got to have a sponsor and you got to work the steps. That is the best thing you can do to help yourself, so that when you get there, you can say, oh, step 4 is yada, yada, yada. Oh, the serenity prayer. Yeah, I can say it for you because I go twice a week. It's got to reach your brain. Please get into your brain. The letters of sobriety are vague, or they don't address sobriety at all. Sometimes not going to be helpful. Oops. Backwards. That if you minimize your problem, if your evaluation, and if your evaluation said go to the meetings, get a sponsor, do it. If you said go to individual counseling, do it. Please. I've had clients who have been diagnosed with severe alcohol use disorder who say they just kind of had a drinking problem. It's severe. It's severe. Okay. Don't minimize it, please. Lying or fudging the truth about your program. I can't, this goes up to the earlier one about going to meetings and not really paying attention. Just be honest, because I can tell you, this is all these hearing officers do. Okay. It's not circuit court. It's not district court where you got some driver's license cases, you got some criminal cases, you got some personal injury. These people, all they do 6 times a day sometimes is they just hear people who are trying to get their license back who swear they're sober. I'm done. I swear to God. If you can't tell me that you've developed a really good BS meter after doing, but if you haven't figured out that these people know how to spot a liar, these people do, because this is all they do all day long. I'm going to come back to your question here, Danero, in just a second. James, maybe you can help me with it once I get done with the slide. You abstain for prior periods longer than your current abstinent period. If you went 2 years completely sober and you've only been sober for a year now, well, guess what? That's not going to look good. If you do the math, Secretary of State isn't going to be convinced that you're not going to go back and relapse if you did it after 2 years and you only got 1 year under your belt right now, right? So it is about timing, making sure you got enough sobriety under your belt. And if you have a history of continuous criminal behavior, like continuing to operate a motor vehicle while suspended, because they're looking at somebody who can be safe. Somebody who's out there still breaking the law is not somebody that they're going to believe is safe, and that's one of the standards. James, what was Danero's question?
All right, so I'll read it for you. He said that this may be very off topic, but here's a question. In your personal opinion, based off your clients, how do we create familiarity with basic legal concepts to better understand the rules so that we become better followers? I'm a military paralegal, and without being a part of the system, so many terms were so foreign to me.
Yeah, the terminology, it can be overwhelming. I do have to say that, and this is at the end, that the number one reason why people lose is that they don't read the instructions. The number one reason why they have issues with their interlock devices when they drive is that they don't read the instructions. The Secretary of State's application, and I didn't put it on the screen actually, but it's not a ton of information, but it really does a really good job of explaining what you need to do, to fill out the form, the evaluator to fill out their form, the letters of sobriety. That at a very basic level is probably the best way to get started. But and unfortunately, this is a lot of people get denied. I've seen a lot of my clients try to do it on their own and come to me. Some people start out and they come to me and it's the first time they've tried to get it back. It's not easy. And that's why lawyers do this work like me, because it's not necessarily something you can do on your own. And so having a good attorney, is really critical. And there are the clinics, and I know James may talk about it at the end. There are some resources that are out there that the state has put out to help people, apply and do this process. I don't think West Michigan Legal Aid does these. They do expungements, but I don't think they help with license. James is saying no. So, I mean, really, at the end of the day, I think the best thing, Denaro, you could do is get an attorney, to help. And even, again, just following the instructions on the forms can be really helpful in honing down and minimizing the number of errors that a lawyer might have to fix. But that I think, having a lawyer with these types of cases, because, and I'll say this at the end, if you lose at the hearing, you have to wait another year. And your chances of winning in front of the circuit court are pretty low. And I'll talk about that. So, I've had clients lose 3 or 4 times trying on their own. And then they come to me and we get them a restricted license at the first hearing. So it can save a lot of time and stress to hire an attorney to help with this process. 15 minutes. So what happens at the hearing? All hearings are conducted by video using Microsoft Teams. They were doing video hearings before COVID, but he would have to go to the branch office and sit in a little room to have a video hearing with a guy somewhere else, or a woman. But now we do them remotely. I do them in my office. I have clients, sign on from where they are. The hearing officer is going to swear you in, confirm your address, confirm all your documents are received. This hearing officer is not a judge. You could say Your Honor, but they're a lawyer, sir, madam, it's fine. But they're just an attorney employed by the Secretary of State. You'll be asked questions about your conviction history, level of intoxication at the time of your arrest and sentence. You're on probation or parole, what you're ordered to do. That'll flesh out a little bit what you put on your application. Your peak use of all controlled substances. So at your height, how often were you doing? That's what they're looking at. So when you were drinking at your height, were you drinking every day? Were you drinking only on the weekends? And when you would drink, how much would you drink? What was your drink of choice? Beer, wine, liquor, and the form, the application allows for you to fill in those gaps, as well as drugs. How much were you using and how often? Prior attempts to stay sober and why they didn't work. Your recovery history, treatment, and your current plan, how you're doing it today, and your relapse prevention plan. What would you do if the thought or opportunity to use came up? How do you get out of there? You can present additional witnesses at your hearing. I don't recommend it. I don't do it. If they have anything to say, have them write a letter, because I'm a type A person. I don't like to give up control as a lawyer. And the more people that I have talking, I'm out of control. It's out of my control. So have them write a letter. The only time I make an exception to that is that I like to have my client sponsors appear, because if this hearing officer can see the person who is your program, this is my sponsor who is giving me my AA, my NA program, whatever it is, and they have so many years of sobriety, and they're grounded and sane and level-headed. Well, hey, they're boosting your profile because this is the person who you've asked to take you through the steps. That's the only time that I'll bring in an outside person. I have a hard time. There we go. Anyway, I'm missing anything out. The hearing officer is going to tell you if your privileges are granted, but more than likely they're going to say they're going to take it under advisement. I'm going to go back, look at your documents, and then you'll receive my decision in the mail. Every now and then, somebody will take pity on my client and say, I am going to grant them to you, but if they don't, it doesn't mean you lost. So don't freak out. But they often, are just going to say, I will consider it once I go back and review what you said now, or what you sent in now that you've said what you've said. So what happens afterwards? You're going to receive in the mail your decision in 3 to 6 weeks, either be approved or denied. If you're approved, almost certainly you're going to be granted restricted privileges subject to an interlock device. Like I said, I had one person out of 150 or so Michigan residents. Now, they cannot order a restricted license for a person who lives out of state. So if you're in South Carolina, you have a hold on your in Michigan on your South Carolina license, or your attempt to get one there. Michigan cannot tell a South Carolina resident what to do. So it's all or nothing, thumbs up, thumbs down, which is kind of tough. And sometimes I think they'll deny you because you're good, but you're not like really good. Kind of sucks, because it's like, what, when are you ever going to come back to Michigan? But Michigan is super territorial about their stuff. And if you broke their law, you gotta, they're going to work you. If you live out of state, no different than they're going to work a Michigan person. They just can't give you a restricted license. Read the instructions in your order, like reading the instructions in your application. Follow them. A lot of my clients have issues with their interlock device because of human error. The interlock device instructions are like 2 to 3 pages if you get a restricted license of the order. And most of my clients, if they run into problems, it's because they randomly decided they're going to use Listerine and then get into their car and drive. Well, it's got alcohol. It can screw everything up. There's all kinds of issues. I'm not going to talk about BAID stuff tonight because it's really lengthy, but read the instructions in your order, cover to cover, reading. You may need to purchase a vehicle. A lot of folks haven't had one. They didn't need one. Again, because you're going to be given a restricted license, more likely than not, you're going to have a car that you can drive. I do not recommend letting anybody else drive this car but you, because other people driving this car will have to use your device. And if they don't know how to use that device, you're going to be on the hook for it. Now, they all these days take a picture. They're going to see if it's you or somebody else, but find a car that's yours and only yours for this purpose and use it. We're going to have to get insurance. It can cost you a lot of money, but insurance companies are out there who will insure somebody who has a revoked license. You're probably going to have to retake your road and vision and knowledge test. If your license is expired, it expires after a period of time. If you somehow are able to get your DUI and your revocation early, I think it's good for like 5 years. Then you're not expired. You don't have to take those things anymore. Most people do. So you got to take the tests. Then you're going to have to get the interlock device installed, provide proof of it to SOS, and then you can finally get your green card that says you can drive on a restricted license. That whole process can take like 6 months. I got one guy right now who we got him a license in September of 22, and he still isn't driving because he hasn't gotten a car. It is what it is. I don't want to fault anybody for that, but it can actually be harder once you get that restricted privilege to get back in the car seat, driver's seat legally. If you're denied, you have to wait another year from the date of your hearing before you're eligible to reapply again. You can appeal to the circuit court and your county residents, but these cases are very, very hard to win. Basically, the court has to find that your constitutional rights were violated. Usually they're not going to do that. And I can tell you that process can take 6 months. So by the time you get done with that, and it costs more money if you hire a lawyer, it's separate, yada, yada, yada. You got to get a transcript reproduced of your hearing. That can cost a couple $100s. But by the time you get through that, you're actually halfway to your 1 year to reapplying with the Secretary of State. Secretary of State is the best forum where you're going to be able to get your license back. And then also, if you are denied, read the order and do what it says so that you can ensure a better case next time. If your order says, we expect you to go to AA, guess what? You got to do it, right? Because then if you come up a year later and you haven't been going to AA and the hearing officer told you needed to go, it's a no-brainer. So read the order, read your application, read. How long does the process take? Less than an hour to complete the application, 3 to 4 weeks, schedule the evaluation, the drug screen, get the results. It could take my clients a long time to get these letters. And I get it, but it can take days to weeks. 3 to 4 weeks to get anything from out of state that you need, or your medical statement from your doctor. 1 to 2 weeks if you have to submit an annual report, if you have an interlock device you're asking to be removed. Less than an hour to submit online. 3 to 4 weeks to get a hearing date. That'll be 4 to 5 weeks out. 3 to 6 weeks to get the decision in the mail. All told, I tell my clients, expect the whole thing, start to finish, to take about 6 months for that first hearing. One little caveat here is that everything must be no more than 90 days old by the time you submit it to SOS. Otherwise, it's expired and you have to get it redone. You might get re-notarized letters. You might have to get another drug screen. God forbid you got to get your evaluation, which can cost a couple $100 redone because it's too old. Otherwise, it's not valid. I mean, if it was from 6 months ago, how do they know? How do they know it's still valid? Start to finish, for a client that has no license today to being full privileges, SOS is out of their business, it can take my clients usually 3 to 4 years. That's what I tell them. So you got to have that 1 year of driving in the middle, remember, on a restricted license. So that's why it kicks it out so long. Top tips, 5 minutes, James. Oh my gosh. Stop drinking. Stop drinking. Stop using drugs. Please, my God. No use is permitted. Don't do it, please. If you lost your license for that reason, but they are going to be looking at, even if it's other reasons, that I could tell you, for causing injury or death, my clients still have to go and do the alcohol evaluation. So you can't use. Read and follow the instructions on everything, please. Check your documents. No inconsistencies. As I said here, I'm a glorified fact checker first and foremost. Be sure your drug screen has all those panels and integrity variables in it. Timing is critical. Don't apply too soon after your revocation. It's unlikely that as soon as your 1 year is up from having your license revoked, that you're going to get it right away. I will generally not apply with a client any sooner than 18 months. Only exception is if they are seriously working a 12-step program and they have knowledge and they know, but just because your 12 months is up from your revocation date doesn't mean now I'm good and I can go back in. This is tough. No amount of time since your last conviction is a guarantee for reinstatement. I've had clients that it's been 20 years and they go back to a hearing, and because of how they answer the questions, they get denied. It's not about time. It's about, are you still a danger on the road? Have you fully acknowledged the scope of your problem? Hire an attorney who knows what he or she is doing. It's not easy. And if your lawyer tells you to lie under oath, please, my God, please don't. Leave them. Don't do it. Serious credibility. It's serious. And this also goes to recovery, being honest. And if your lawyer is telling you to lie, get another lawyer. I don't take this stuff. I take that very, very seriously. Get another lawyer. Things we didn't cover tonight, James, and everybody else out there. Reexamination for license suspensions. It's its own little creature, not as anywhere near as difficult as this, but separate. Handling out-of-state restoration applications like holds. It's very similar to what we talked about, but it can be a little more difficult because you got to get this stuff in a state where I don't know anybody, you don't know anybody, but it's possible. Proper operation of interlock devices. These things are super tricky, super finicky. I would say that 90% of the people that I represent have some kind of problem with their interlock device in the 1 year that they're operating on it. And the other thing I should say, some of these folks will continue to drive for years with an interlock device in their car. As soon as your 1 year is up, get that thing out of there. It's a hand grenade with a loose pin. You're asking this thing to test you every 15 minutes as you drive. Don't mess around with these things. Read the instructions. Yeah.
So for that interlock device, if you don't get rid of it in time, does it still report that same data, and can that data hurt you?
Yes, absolutely. So they're not going to call you in. You can continue to drive. So, Secretary Stan, I'm not going to call you in because your 1 year is up. You can continue to drive this vehicle legally with an interlock device. But that interlock device requires you, in order to be compliant with SOS, to go in and have it downloaded every 2 months. And every time you go in for a downloaded, they pull all the info off. And the bad stuff will happen. And it'll show up and it'll get sent to Lansing. Lansing will call you in. I've had clients get get into that position where they were ready to apply for reinstatement of full privileges and got violated, didn't have a good enough reason, and they went back to total revocation. I had a guy just last year. It was heartbreaking. This guy's been driving with an interlock device in his car for like, I don't know, 8 years. I helped get it back in like 2015. He got violated and he didn't have a valid enough reason. And the hearing officer said, you're going back to square one. And he has no license today and now is going to have to start over from scratch. We didn't talk about interlock violations, which are super tricky. Circuit Court appeals, super tricky. Overcoming your credibility issues. If you've had hearings before and you've lied under oath and you've been caught in that lie, it's a nightmare to try to get out of. Because if you're the number one source of information, how are you going to recoup your credibility if you were caught in a lie previously? I work with clients on that, but I can't talk about it tonight. And then the addiction mental health component, because it's a real thing. A lot of folks lose their license because they are alcoholics and drug addicts. I'm not gonna downplay that, but there's a way to address that because it overlaps into driver's license restoration. Didn't really talk about it tonight, couldn't. So that is 7:01, James. And you said you had like 10 or 15 questions for me when we prepped for this thing. What do you want to do?
Tell you what, I don't want to keep you too long.
Let me ask this. What did any of this cover any of those 10 or 15 questions that people sent you in advance?
I think you covered just about all of it, and you also shed some light on what we didn't cover. So maybe we could do something else maybe later on about the things we didn't cover.
I'm happy to.
Those things
there's
come
a lot of pieces. Yeah, there's a lot of pieces to this. And like I said, so I got this PDF. I can PDF this out, and James, this will be recorded. It's recorded and be available later on demand. And there's a lot of stuff in these slides. I get it. I mean, I spent a lot of time putting this stuff together, and we can help get it to you. If you want to know James, you can reach out to James. Even the expungement one from last month too. Coming up real quick. So next month on the 21st, we're going to talk about estate planning, wills, trusts, powers of attorney, that sort of thing. Due process for dads. It matters. I mean, it matters even somebody who's my age, good health, having a plan, what's going to happen to you. Even like if you're a single dad, let's say, and mom isn't in the picture, or mom, women could be watching this. You can name a guardian or conservator in your estate plan. So if something happens to you, who would you want to take care of your minor child? That'll be part of what we're going to talk about next month. And then in January, February, and March, we're going to hit all of the family law matters and wrap up in April, at least for now, with guardianships, and which is like custody, but different. So that's it.
Yeah. Well, I know that's our time. Blair, I want to thank you again for agreeing to do this series. We got 2 down, 5 more to go.
You got it. It's been a pleasure, James. It's helping me kind of get all my thoughts together, and I certainly enjoy educating whoever wants to learn about this stuff and having it out there. So thank you for making this as a resource, going forward for folks. Appreciate it.
So for anyone that's looking to watch this in the future, you can find it on Facebook at Present Pillars. You can also find it on our YouTube page. If it's okay with you, Blair, we'll be uploading slides and different things like that to our website in the coming weeks. So if anybody's looking for that information, go to presentpillars.org. All right. So that's our time. Thanks again. Thanks for watching, and we'll see you next time.